Thank you very much for attending today and welcome to our presentation on aluminium composite cladding. My name is Anthony Herron and I am a special counsel from Herron, which is a construction and engineering law firm based in Sydney. This is part 2 of a series of podcasts that provide an update on developments in the law in relation to aluminium composite cladding. Let's have a look at some of the case studies. Having seen some of the advantages of ACP, and we've seen some of its dangers, let's have a look at several case studies. We'll start with the Grenfell Fire. Now, this fire happened in June 2017. It resulted in the deaths of 70-odd people in the United Kingdom. There has been an ongoing inquiry which started in 2018 and 2019. In the last 2 weeks, phase 2 of the investigation has commenced. What phase 1 of the investigation from Grenfell discovered was this. Firstly, the origin of the fire starts quite innocently. It was started in a unit on level 8. The resident noticed the fire. It started in a refrigerator. So clearly there was no element of blame or fault which could be laid at the door of the resident. He called the fire services and the fire brigade came. What the fire brigade's London Fire Brigade found was that it was very difficult to try to work out a strategy to actually deal with the fire. This is because originally they called 4 pumpers. They eventually called 20 pumpers. And the inquiry found that the reason for the fire spread was the use of the ACP. The Australian or the Aluminium Composite Cladding. They found that the building had several years earlier undergone a series of refurbishments. So we have an older building, probably built in the 70s. They decided to encase it in this composite cladding, and a series of designers were engaged to do that. The inquiry found that there had been a loss of compartmentalisation. So this very issue, now consider back our first discussion point about how do you safeguard the residents. What they did find was that because of the fire spread from the source of the aluminium composite cladding on the exterior of the building, so the fire started outside the building, it then moved inside and then raced up to the outside. And that happened within half an hour. By the time the brigade was there, after 1 hour, they had not given an order for the evacuation of the units. So people were trapped inside. They were told, stay inside. It was until a further higher up commander decided to arrive that he issued the order to order the evacuation. The inquiry found that more lives would have been saved had they issued the evacuation order earlier. They also found that there had been human failings in terms of the way in which the fire brigade and the rescue services dealt with the fire itself. It wasn't their presence or their lack of understanding. What the inquiry found was that they did not have an appreciation, nor did they have a policy or a plan to adequately identify and deal with the aluminium composite clad. In other words, how do we extinguish the fire which essentially had lit up all 4 elements or facades of the building. They also found that the source of the fuel was the aluminium composite material, they call it. These were formed the sheathing or external casing of the building, and those contributed to the actual fire spread, rapid fire spread. They also found that there had been failings in the rescue services. So here we have the problem with the materials. There was also a problem with the training and the policy and lack of direction and operation by the London Fire Brigade. Unfortunately, it resulted in the Chief Fire Officer of the London Brigade tendering her resignation in December last year after some considerable pressure. I think that there were also a number of failings on the ground in terms of the administration of the rescue services, how to actually address the extinguishment of the flames. And in fact, those flames were still burning a week later. So they found that the use of the combustible materials was the source of the fire spread. It was a real disaster. And as I said, What it did do was it caused, from the Australian perspective, a real consideration of what, as a country and from a state-to-state perspective, do we do about providing for appropriate protection for buildings that are clad in aluminium composite materials. As I said, phase 2 of the inquiry is in the course of understanding more about the choice of the design, who was responsible for the design of the cladding, who was responsible for its erection. Did, for example, the suppliers and designers have an understanding before the cladding was installed and designed about whether it complied with the building code? The first stage of the inquiry found that the designers were aware that it did not meet the building regulations. What that says to me is that there is a very strong likelihood that there will be criminal prosecutions arising as a result of this particular incident. I'd also suggest that those prosecutions might arise in relation to the designers, the cladding manufacturers, and there might also be some issues finger pointing at the London Fire Brigade. There are some very helpful issues that have been raised about the Grenfell inquiry and the discussion by the witnesses in the Guardian newspaper that put out a number of very helpful publications on this issue. They have covered the inquiry very carefully, trying to take into account the interests of the occupants and their relatives, and try to understand more about what led to the cause of the fire. As I said, in the course of the last week, there have been submissions made to the inquiry about the designers and suppliers seeking immunity from prosecution. So in other words, there has been an application made by the judge who's conducting the inquiry to the United Kingdom Attorney General to grant an immunity from prosecution for witnesses who will yet take the stand from potential prosecution in a criminal sense. That is being opposed by the residents, who say that any immunity request would hamper any likely bringing to justice of those responsible. On the other hand, I think it's the view of the Commission and the lawyers representing those other parties that were responsible for the design and construction of the cladding, that it's only with this potential immunity from prosecution that the inquiry will truly understand what led to the actual construction and approval of the cladding itself. As I said, this slide indicates potential liabilities, so we have an understanding already about likelihood of civil claims, which are an example of what happened with the Lacrosse building. There's liable to be criminal prosecutions and potential issues raised with negligence and manslaughter, both at a corporate and individual level. And I could also foresee those potential criminal prosecutions extending to some of the directors of the parties responsible for the design and construction and supply of the cladding. The other reason that this inquiry is of some significance is that there have been discovered to be more than 400 buildings around the United Kingdom with a similar amount of cladding or similar style of cladding erected. So that is why this is quite a big deal, this inquiry. What it will also do, it will inform other countries about stances in terms of a policy perspective about what sort of issues should be raised in terms of regulation, of suppliers, of manufacturers, of certifiers, and those parties who are responsible for providing advice in the early construction stage and pre-construction stage about the actual choice and design of the materials chosen to use as external cladding. Lacrosse. You're probably familiar with Lacrosse. It's a decision of the Victorian Civil Administrative Tribunal in February 2019, Judge Woodward made a decision in which he awarded some $12 odd million as a result of liability flowing from the Lacrosse Fire. Fortunately, that fire did not result in any public loss of life. It did cause some considerable damage to the building. The damages that were awarded by the judge were the result of placing or a recompensation for the costs of replacement of the various goods and materials, and also to try to remedy the defective building work which arose as a result of the particular cladding. The next couple of slides just set out an illustration of the sort of public interest that has arisen as a result of the Grenfell inquiry and fire, and then the Lacrosse Fire, which happened in 2014. There are some considerable similarities in terms of the fire spread, the source of the fire as discovered between Grenfell in the United Kingdom and Lacrosse, which we'll get on to at the moment. The Lacrosse Fire happened in 2014. It involved the building which had been established, set up for some time. It was the result of human error. So Mr. Gabita was living at the premises. He was smoking a cigarette on the balcony, and like everything, left it in a plastic rubbish bin, and what do you know, it started to catch fire. There was an alarm raised externally to the fire brigade. They turned up. Within half an hour, the fire was spread, as you can see from the slide on the left-hand side, up the side of the building. So this is just an illustration of the difficulty faced by the use of the aluminium composite cladding. The judge found that the source of the fire was the cladding itself. The judge also found that there had been mistakes made by the designers and the architect. Firstly, what was supplied and specified was not compliant with the Building Code of Australia. Secondly, what in fact was constructed was also non-compliant with the Building Code of Australia. So from quite an innocent beginning, you have a tragic outcome. As I said, fortunately, Lacrosse resulted in no loss of life. The second slide on the right-hand side shows the effect of the fire spread. As I said to you earlier, with the fire or the cladding itself being clad over the external part of the building, what caught fire was the cladding, the core, within the metal sheets or the aluminium sheets. This resulted in a very rapid fire spread, which resulted in considerable damage to the building. Fortunately, the sprinklers became effective and doused the flames itself. So that led to the fire being extinguished. The next couple of slides indicate the source of the fire spread, which we won't go into any detail. But nevertheless, what you have is the use of a product such as aluminium composite cladding, widely used, which was the resulted in considerable fire spread across the external element of the building. As I said, fortunately, there was no loss of life, and secondly, the flames were extinguished. Nevertheless, what it does show is that use of these products present challenges for rescue services in addressing these specific issues. How do we actually extinguish a flame? How do we manage crowd control? How do we evacuate parties? When should we do so? From a designer or policy perspective, from the government's sake, how do we as a government try to legislate with those two things in mind? When we are using new products, such as aluminium composite cladding, or whatever product we call it, how do we actually legislate to ensure that we safeguard public life, and secondly, that we minimise fire spread? Let's look at the findings of Judge Woodward in Lacrosse. I might say that from my research, the Victorian Court of Appeal is due to hear the decision or an appeal in around the mid part of this year. The appeal has been brought by the architect, the certifier, and the safety engineer, and they are claiming that the decision of the judge should be overturned. Let's have a look at briefly what the judge found. Essentially, he found that the builder, L.U. Simon Pty Limited, was negligent. So and in breach of the warranties under the Domestic Building Contracts Act, Victoria. That is very similar to the Home Building Act in New South Wales. We have a residential building where you have warranties for the fitness for purpose of product, fitness for purpose of the actual work and professionalism supplied by the contractor. So in Victoria, the Domestic Building Contracts Act governs these particular types of residential construction. The judge found that the builder, L.U. Simon, was completely liable. He found that the liabilities faced under the warranties, in other words, these contractual promises were implied, they were non-apportionable. In other words, the builder couldn't pass them off to somebody else. That has similarities to the Home Building Act in New South Wales, where the builder and the developer will be found, if there's defective and or incomplete building work, to be completely responsible for a defective and or incomplete building work. What makes this decision of Lacrosse very interesting is because for the first time, the court has actually considered the liability of parties beyond the constructor and or the developer. And in fact, that's what the judge did. What he did find was that there should be an apportionment of liability. He found that the builder, as I said, was liable. The builder had breached its statutory warranties based on the statutory warranties based on the Domestic Building Contracts Act, but that there were other parties that should share or take an apportionable element of the liability, being the architect, being the fire engineer, and the surveyor. The superintendent, Property Development Services or Solutions, wisely was able to cut a deal before the case commenced and was not included as part of the proceedings. Nevertheless, the judge made a finding regarding its liability. But he found those three parties being responsible, being the surveyor, the architect, and the fire engineer. The surveyor was found to be responsible, as was the architect and fire engineer. We'll just have a look at what the judge found. So the first element of liability on the first level relates to the builder, L.U. Simon. Breach of its warranties, the product that it used was in breach of the statutory warranties under the Act. The materials were not fit for purpose because they breached the Building Code of Australia. The three other parties that have all appealed, the surveyor, the architect, and the fire services engineer, were also found liable. The surveyor was found responsible, equivalent to 33% of the judgment, the architect at 25%, and the fire services engineer at 39%. They were each found to have breached their responsibilities based on their contractual arrangements or agreements with the builder. And on that basis, the court found that any liability that the builder found should be apportioned and to those other three parties. So essentially, based on the first judgment, the builder has walked away scot-free. In terms of the surveyor, the judge found that the architect specification did not comply with the Building Code of Australia. So there was found to be a clear breach. The architect had failed to remedy various defects in its own design. So as a first point of principles, the architect was found to be responsible for the breach of the Building Code of Australia, in that the design was not fit for purpose. And the person that copped the most liability was the fire services engineer. It was found to be in breach of its engineering assessment contract, and also it had failed to recognise that the aluminium composite cladding which was used and specified was not compliant with the BCA. It also failed to warn the other parties that there was a breach. So that is why this decision of Lacrosse has had enormous ramifications, and why it has caused public policymakers and lawyers alike to consider afresh whether in any building defect claim, particularly involving the use of defective materials and or design, as happened in Lacrosse, as happened in the other fires we'll look at, may result in considerable liability to other parties that traditionally have escaped liability. The next slide indicates why it is important when at the construction phase or pre-construction, when advising a consultant or considering overall liability, if you're advising a constructor and or a developer, whether you have adequate insurance coverage, whether the contractors and consultants that you have engaged have the adequate expertise and insurance, and have adequately considered the relevant statutory requirements. Now, the purpose of this slide is to indicate the parties on the one side, then their fees they generated, and then the apportionment of liability. So, for example, the builder netted fees of 96 million, a finding of 0% apportionment. The architect had fees of 2.66 million and was found to be 25% responsible. The superintendent was found, had generated fees of almost 900,000, but found to be 0% responsible. But the building surveyor and the fire engineer, who had negligible fees of 100,000, and the fire engineer at 33,000, both of whom faced the major element of liability. So the fire engineer, generating fees of 33,000 for its work with Lacrosse, was found to be responsible for almost 40% of the overall judgment. So bearing in mind a judgment of 12 million, that's a considerable liability based on what one would think if you're engaged as a consultant should be a fairly low risk enterprise. That I think is probably one of the reasons behind the decision by the parties to appeal. It also represents, I think, an interesting comment by the architect that their view is that there has been some injustice done by the Lacrosse decision, excuse me, in terms of the builder having been found to be in breach of the statutory warranties, yet bearing not $1 of liability based on the original judgment. It would be interesting to see how the Court of Appeal treats that decision. I think much of the decision will be based on the facts of the case. Much, I think, of it will depend, can be used in terms of a limited scope to other cases. What I think it will serve is an illustration of the importance of, one, good expert evidence to identify the cause and origin of the fire or particular defects. Secondly, understanding whether the consultant retained has adequate and appropriate insurance cover. Secondly, understanding whether there's been adequate communication by the consultants in terms of, one, consideration at every stage whether the Building Code of Australia has been complied with. If not, alerting their client, for example, the builder and or the developer, about that, and putting that in writing. And then the supplier and the safety engineer, who really form a very important part of the involvement of any product, making sure that any product that they specify complies with the BCA, which is then in vogue. Just some comments there about the use of the ACPs, and as I said, I think there are some lessons here which we'll briefly cover in the next slide. I think it's fair to say that while the builder in this case had a 0% liability, I would be surprised if the Court of Appeal found that that was to be the case. In other words, that decision was maintained. It seems to me a little unusual to have, with respect to the judge's finding, to have a 0% liability in terms of liability and dollar terms, yet to have been found to be in breach of the statutory warranties. So, for example, in New South Wales, if you're in breach of the statutory warranties as a builder and or a developer, that's automatic liability. What I could see is, or can foresee, is some potential further sharing or apportionment of liability between the builder and the various consultants. What the judge did find, though, was that there had been really onerous breaches by the consultants who were brought in as experts to advise the builder and the principal in terms of whether this product they were being used and supplied and specified was in breach of the BCA. I think for consultants there's a lesson as well. If you're acting for a consultant, try to ensure as much as possible that you can place a cap on your liability. Second, have adequate and appropriate insurance. If you are acting for a principal and a constructor, ensure that as much as possible, if at all possible, when you're negotiating the contract, that you have as little, or that there should be no cap on liability. Next, we'll consider insurers. Now, from an insurer's perspective, subject of course to the Victorian Court of Appeal decision, I'd suggest that as a result of the Lacrosse decision, insurers may impose exclusions and or increase premiums, and I'm certain that that is the case, bearing in mind our discussions with industry colleagues from insurance. But I'd also suggest that from a professional's perspective, particularly regarding consultants and those providing professional advice in the construction space, that they consider their duty of disclosure to insurers of incoming policies, in other words, their previous involvement on construction projects, and any, in particular, claims that they may have experienced arising as a result of their involvement in the construction process. They should also notify as soon as possible, in the event of a claim, to trigger cover under an expiring professional indemnity and policy. So I think those are some important further lessons to be learned from the Lacrosse decision. Now, the next slide provides a timeline of the issues arising in relation to combustible cladding. What this slide shows is a series of the major events which have occurred between 2017 to the present time in relation to combustible cladding. But not only that, what this slide also seeks to do is it seeks to identify the involvement and policy responses that have been provided by the various state governments. And I've emphasised in particular the responses from Queensland, New South Wales and Victoria. That is not to discount the involvement of other states, but just space permits being able to discuss all of the particular issues. But the important thing to understand is this, that arising as a result of the Grenfell Fire and the inquiry, and the fire occurred in June 2017, that really served, as a trigger to state governments in Australia to consider their policy positions. In other words, to understand whether they had sufficient regulatory regimes and processes in place to deal with defective products such as aluminium composite cladding, or panelling as we'll call it. Now, what that really started with was that various states introduced a regime whereby they would carry out and organise a regime of a understanding which buildings were affected with, or in other words, had constructed aluminium composite cladding. That has not been an easy process. They've done that through a system of online registration. So for an example in New South Wales in February 2019 provided a date by which the interested parties and owners, corporations, owners of buildings would carry out their online registration as to whether their buildings had aluminium composite cladding. Now, other states followed similar regimes as well. So that was done, for example, in Queensland. That happened in October 2018. And New South Wales was roughly the same time. Now, before that, and one of the things that really was the origin of the ban on certain aluminium composite cladding was the decision by the various Senate committee reports, starting with that in the end of 2017, to decide to ban building products which contain aluminium composite cladding. Now that happened effective in New South Wales on 10 August 2018. And what that ban provides for is that there will be a ban on aluminium composite cladding on buildings with a core of more than 30% polyethylene by mass or weight. Other states have followed suit. So what you have is you have a ban on the use of aluminium composite cladding where you have more than 30% of the core with the polyethylene content. And certainly, for example, with the Lacrosse Fire, they found that the building did have a aluminium composite cladding. I think the same happened with Grenfell. So these changes have been welcome. In addition to that, we have, in February 2019, we had the Neo 200 fire. Now, that was a building with it's a very large building on the approaches to from the airport. It's in Spencer Street in Melbourne, so it's a very highly visible building. This particular fire happened in February 2019. In fact, I think it was might have been January. It was some 28 days or so before the decision of Lacrosse was handed down. But this building, the fire started on the 22nd floor. The cladding was wrapped around the balconies, and the couple of interesting facts that really tie it to the Grenfell decision was that they had the same materials as the Grenfell building. So in other words, you have similar aluminium composite cladding in both the Grenfell building and the Neo 200. They also had two previous audits that had been carried out by the cladding audit committee set up in Victoria. They had also been hampered in the rescues by the residents, which had covered alarms in plastic. So what that says is that you have a problem with the building material itself that resulted in a fire. There was significant damage. Fortunately, there was no loss of life. But you also have the same building, same builder, with LU Simon, as happened in the Lacrosse building. So what that says to me is that you wonder what the result of the inquiries will be coming from that fire. Nevertheless, there was no loss of life, fortunately. There was damage, and what it does show is the danger of using an aluminium composite cladding without having proper processes to ensure that it is removed. Thank you for listening to our podcast. In our next podcast, I will be looking at some of the reform initiatives taken by governments to address the problems raised with aluminium composite cladding. If you would like some more information in relation to this topic, please visit the articles on our website and also download our ebook on cladding updates. We look forward to connecting with you in the next podcast. Should you require any assistance, please contact us.